Welcome to the No State Project live from the fortified compound in Mesa, Arizona. Glad to be with you. We've got people already filing in, so glad to see that. Appreciate everyone taking the time out of their day to tune into the big show here on my YouTube channel, No State Project. And I'm assuming that everyone that's watching now is already subbed. So good on you. And hopefully, if you're not subbed, you'll get subbed so you'll be able to know when we're going live. I'm just not the type of guy that I just can't stand those guys that do and smash the like buttons, hit the subscribe, get that bell. If you're interested in subscribing, then you will. I just think that's kind of an obnoxious thing. You're like, well, yeah, Mark, well, they've got a hell of a lot more of an audience. Well, they got a different type of show. Material that we talk about here on the No State Project, yeah, it's going against the grain. It's questioning things. It's going against the orthodoxy. So I get it. A lot of people just tuning in because they have traffic tickets, and when they get them tossed out, then they move on. Maybe listening occasionally, but appreciate everyone tuning in. If you want to join me on the big show today, it is 717-275-8941. It is in the show notes, so if you're watching this live, you can get that. But it's 717-275-8941. The passcode 1233428. So if somebody can then put that and copy and paste that up, yeah, everybody doing over there. Yeah, you can also get me on that there Skype, but please instant message me first at Frank Rizzo 3. That's with the number 3. So yeah, what's up? Well, it's January 29, 2020. And good news. Not doing very good on getting this stuff posted, but I'm getting back. I've got 3 success stories now that I've got to post. I lost kind of track of some of the earlier ones that I didn't get posted last year, but I'm making sure that I get them in the right folder so that it's easy to get to. But just a couple days ago, I think it was Monday, someone else, and I believe they called the show because it was regarding Head of the Harbor, which is a beautiful part of Long Island. Right, as you would imagine, it's on the water. It's the North Shore of Long Island, right next to Stony Brook. And it was a traffic ticket. They had called in about it, and it was tossed out. So it was dismissed. Very nice. So big congratulations there. I'll have more details, I'll have the actual documents. Of course, when I talk about success stories, I like to have the evidence. And yeah, there'll be people that will. Yeah, and somebody had left a comment. I shouldn't do it, but I look at it on my phone sometimes. And a comment I haven't seen in a while. It was like, well, except for traffic tickets and minor stuff, is this guy held anybody get anything significant tossed out? Well, depends on how you look at significant. What's significant for you may not be significant for somebody else. And if you're not the one going through the attack, yeah, so Joe in Hawaii getting marijuana charges thrown out, that they were serious enough or significant enough that the police felt they were justified in raiding his house. And that was all tossed out. So some people may look at, well, marijuana charge is not significant. All right. It's most of what I do is minor stuff that people can defend for themselves, to where there's not a huge risk, so that they can learn how to effectively defend themselves and make challenges to the prosecution's case that a lawyer or a prosecutor or a public defender or a private attorney may not feel very comfortable doing. So if it's just to take a shot at me, whatever, there's a substantial body of evidence that's very effective, and people are getting tickets thrown out. So yeah, it could just be traffic. Yeah, all right, we'll give you that. I gotta accept. Yes, this latest round, this latest win was 2 traffic charges, but for people like me, $1,000 fine is devastating. I mean, that could ruin your finances for a long time, at least for me. I would say, for the average person, they reported a year or two ago that $400 would wipe them out. So your average traffic ticket is probably $500-600. You're doing significant economic damage to some people, to a lot of people, most of us. So it may not be significant to a lot of people or in the whole scheme of things, but it's nice when you can stand up for principle and get the damn thing tossed out. So if somebody wants to piss on the work that way, well, okay. It's not something that I'm not 16 years old. I don't need to have everybody, obviously, looking at the numbers. Obviously, I'm not sitting here looking for, for mass appeal. Oh, I've got like some people, that the whole thing is an ego. I got to be able to brag that I got the largest podcast in the world, I know for ego and for the money that comes with it. So, but congratulations to everybody who has defended themselves, even if it was just a learning process, that you're able to go through the process. So if there is something more significant, you're more confident and more prepared and more effective in defending yourself there. So I know I'm not going to be doing shows next Wednesday and that Saturday. So because of that, yes, I will do everything that I can to make the time to at least get a 5-minute screen recording so I can get the video up with the documentary proof, and to not just the documentary proof, but also, they have in the video, but also to have in an article at markstevens.net that you can download the proof. I haven't heard back if I can post it without redacting the case number, this latest one. But the one I got before from New York, I can do it completely unredacted. So, I'm still gonna redact out his address, but his name and the case number and everything else will be totally unredacted. So, so that's great. I really, I'm glad that they stood up for the principle and they defended themselves. But again, I'll give more details about that. Besides that, it's just traffic, and maybe as my thumbnail, I'll have that the Redditor, the big fat Redditor laughing. Oh, I just posted it was just a traffic ticket. Yeah, you showed me, all those few handful of people that got to do that. So. What's the biggest mistake people make in these traffic courts? Tim's asking that. Well, what's the biggest mistake? I know a couple of the biggest mistakes is accepting their answers, accepting non-responsive answers, to where you're getting the focus off of the prosecution's burden of proof. Not asking leading questions and making affirmative statements is really bad. Or if you're just asking open-ended questions and you're not prepared to deal with the answer effectively. And I go through this all the time when I'm doing consults, or even here on the show, where I'll ask questions, or we'll go through a little scenario like we're in court, and they just freeze because, let's say, they're asking an open-ended question and they're not prepared to respond to which you shouldn't be, responding directly to the narrative unless it actually answers the question. And if it answers the question, you damn well should be able to handle the answer because you asked the question. So those are some big ones. I think not accepting or not being skeptical is a very big one too, and taking whatever they say at face value. You have to assume that everything that they're saying is a lie. Now, I'm not saying that every prosecutor is a Stephen Myrie, that it was just just a fire hose of lies, and that that they're always withholding exculpatory evidence and withholding Brady material. Not all prosecutors do that. I said before, I know a prosecutor here in the Valley, and he doesn't do that. So, hey. So not every prosecutor is a Stephen Myrie POS, but it definitely helps to better defend yourself if you assume that they are. That doesn't mean you treat them unprofessionally. I always advocate we're going to treat everyone the way we want to be treated. You treat them with respect until they show that otherwise that they're not deserving of that respect. But even still, we should take the high road against them. But a lot of times people get into trouble because they're accepting something that the prosecution said as true without challenging it. Your job is to defend yourself. Our job is not to accept what the prosecutor is saying is true. Our job is to make sure that the prosecutor verifies all the claims that they're making. So that someone saying my dog Rex, the biggest mistake is appearing as U.S. citizen / property. Oh, all right. Their jurisdiction is not based on whether you're a citizen or not. It's not. It doesn't matter what someone's political affiliation is. If they see you physically in Arizona, they believe that they have personal jurisdiction over you. That's it. They don't give a damn whether you're a citizen or not. Because if it was based on citizenship, what do we do about an alien? So, someone saying real jingy, pathologic liars, the whole lot of them, prosecuted judges and cops, all the same fascists. I think it's safe to assume that they are all lying. I wouldn't say that they're all pathological liars. I think they're people who know they're lying. They just don't care. It's a power trip. But I think it's always better to assume they are lying and so that we're asking good leading questions to get them to verify that what they're saying is true. But if they commit the crime of fraud by omission of known material facts, why are we obliged to even go one step further? Well, I'm not saying that you're necessarily obliged to participate in these sham trials. I talk about participating in these sham trials as a matter of limiting the damage they want to do. This is not a matter of, hey, this is an invitation. Come and join us if you want. No, this is you participate, or we have what's called a force continuum, and we will use whatever force is necessary to get you to participate. So I'm trying to limit the damage because I know, Frank, that not participating and just blowing it off, they issue warrants and it escalates and it almost never works out in your favor. Always show up in good, that you're trying and good, exercising good faith. We're the ones that want to resolve this. We're the ones exercising good faith. We are just trying to hold them to their burden of proof based on their advertised rules. And through asking leading questions and challenging, we're bringing out that they can't be consistent with those rules. So where they even start to argue, like Tiffany Castillo in Massachusetts, I think it was a Kankid. She was arguing, like some of them will do in court, they are not required to prove jurisdiction. I just had someone email me the other day. The prosecutor came flat out and said they don't have to prove jurisdiction. Now, I would imagine that even critics to the show, to my work, would have to say, "Ooh, that's actually not true." They actually do have to. I mean, we even had the little Dutch boy himself up in New Hampshire that jurisdiction is a pure issue of law. It requires no evidence to prove it's true. All the prosecution has to do is prove you're physically in New Hampshire. So they typically admit that they do have a burden on jurisdiction. The disagreement is on how far that burden has to be taken. So this prosecutor now is saying he doesn't have to. He has no burden on jurisdiction at all. Not that he's proven it. No, this prosecutor is saying, and I'm sorry, I don't remember where it's happening. I'll have to look that up, and maybe if I can remember to report that on the Saturday show. What's important is we have this is what some of them will actually do. Now, whether the judge is going to buy that, I don't know. I personally think that that's a serious ethical violation. If a prosecutor is making a legal argument that they don't have a burden to, as the plaintiff's counsel, that they don't have a burden of proving jurisdiction, that is not a good faith argument based in fact and law, because the plaintiff always, whether it's civil or it's criminal, doesn't matter. Whoever relies on the court's jurisdiction bears the burden of proving that it's true. And here we got a prosecutor, I believe, making a very serious ethical violation and prosecutorial misconduct by arguing he or she does not have the burden of proving jurisdiction as plaintiff's counsel. But all right, this just gets again to the point that we have to assume that what they're saying is false, because it's not always going to seem quite as obvious. It's not going to always be a prosecutor coming out and saying something that even the critics disagree with, where they'll come out and say, I don't even have to prove jurisdiction. That's not a burden of proof of mine. And so Frank is saying, but there are court cases which state that jurisdiction once challenged must be proven. Yeah, I get that. They say that, but you have to be very careful. The Higgins versus Levine is a paraphrase, and it's not, and what you see online, it's usually not, and it's been circulating for 20 years. What they're saying in Higgins versus Levine is not a direct quote. That might be actually what the case is saying, what the court's ruling is, but it's not the same exact words. So, you got to pull the quote. You're better off always citing word for word exactly the court ruling. What did the court hold? All right, the legal principle the court is holding here, okay, is jurisdiction once challenged must be proven, and that is true. Personal and subject matter jurisdiction cannot be waived. But that just because that's why I'm saying that the prosecutor is arguing in bad faith, because it's not based on law. Current law, which has been for 200 some odd years or more, is that the one who relies on the court's jurisdiction, like the plaintiff, bears the burden of proving that jurisdiction is there. It's not the judge's job. The judge is only there to make sure that the prosecution has met their burden, and that burden depends on what stage of the proceedings you're in, whether it's arraignment, pretrial, or a trial. So Craig's saying, isn't the imaginary lines a foundation of this false belief of jurisdictions? That Craig said that. Well, yes, they believe that the territory within those geographically, those lines, as it was Arizona or the state of Arizona, that physical territory, that their constitution gives them jurisdiction, or in other words, power to act in that physical territory over the persons or the people, the men, women, and children, and the property within those geographic boundaries. I think it's a losing argument. Yes, the courts accept it. Yeah, no question. I think it's a false argument. I think the facts there's no facts to support it, and the facts are actually against it. But these are things I would, these in a lot more detail when I have time, is when I would cover things in a workshop. So what I have, which is actually still this actually might not be a permanent title to this show, in that a workshop here in Arizona. So non-entity who's called the show before, known him a long time, called and floated the idea of doing a workshop here in Arizona. And I like the idea of doing it in Arizona because it's a lot easier for me to put together, because I don't have to fly. I don't have to rent a place. It's easier to travel to. So a workshop based on, that we would go through how to be more effective defending ourselves in court, really covering what I have done in the past and why and what the results are, so that people can make up their own mind whether that's something that they want to do. I'm not making any suggestions other than make your court dates on time. Don't go blowing things off. There's actually people that I knew someone who his own son murdered him about 12 years ago. And he came over from Right Way Law in Ohio. And he was one of these guys that would take $5,000 retainers, $5K. And he would guarantee he could get prosecutions stopped against you. And so there was somebody who was called by the grand jury and subpoenaed as a witness. And what his $5,000 got him was this legal advice. 3 words. Don't show up. I'm not kidding. I'm not saying that this was a right-way law legal defense. I know this guy wasn't, I guess he called himself one of these common law lawyers. $5,000 not to show up. And the guy that he paid. I helped clean the mess up, which is the first time that I became aware that I was under, well, because of the person I was helping, I was under surveillance. So if you ever call an Uber, well, it was, or if we had called the taxi and like an idiot, the taxi pulls up and another one pulls up right behind and says, no, we've got so-and-so. And like an idiot, we got into the second one. Well, it was an FBI agent that was driving, and recording the whole conversation. Well, thank goodness I was in the practice of never discussing in the court building or in the or the government building or in a cab or something like ever discussing the merits of a case. And I would suggest the same. When you walk into one of them buildings, keep your mouth shut about your particular situation. So we talk about at workshops, the basics, and go and also do role playing and do mock court proceedings in order to get if you're new, get your feet wet, what you can expect when you go to court. And we put the basics at work. So if you are in Arizona or near, it would be in Oracle, Arizona, which is about 2 hours southeast of Phoenix. So yeah, I would be driving about 2 hours myself. So if you are in the Phoenix area, the Valley of the Sun there, not so much the Valley of the Sun today, but yesterday, oh my gosh. I don't even get me started about how nice the weather was the last couple of days. Holy crap, 74 degrees. 74 degrees. What is that, 30 Celsius, something like that? Pretty damn nice. Pretty damn nice. So anyway, it would be in Oracle, Arizona. And so if you're interested in doing a workshop on how to more effective principles that have been used before by me and others, and the evidence, I'll have more this week, markstevens.net, of dismissals and being able to effectively defend ourselves and get these code violations tossed out, then let me know. Marc Stevens at mail.com. I'm at Frank Rizzo 3 on Skype. And you can just call the show and say, hey, jerky, I'm interested. I'm in. So I'd like to get kind of an idea of what kind of, how many people we're looking at doing this. So, and hey, depending on what venue that we're using, because I don't even have a venue picked out yet. But depending on the venue, I might bring the Les Paul. So that would be sweet. We'll see. We'll see. Is it time to get to the phones? The number. All right. Mark, what about an online workshop? I'm too far away, but I do sign up to workshops online for other reasons. That was something I need to get back with Vin James about. Just a lot of stuff happened. I had a death in the family, and even recently a friend that I was a guy I've known for 20 something years, who was a roommate right after Christmas, just suddenly dropped down, dead of a heart attack. It just fell off I am interested in doing that. It's something I got to get with Vin James and coordinate, because that was kind of, he floated the idea to me first. So I want to get back with him and see what we can do about that. I certainly would welcome the opportunity to do that. It's a matter of scheduling. And I know there's an 8-hour difference, so I'd have to get up pretty early. to do that. So, and I'm kind of a baby that way. So, but we can work that out. We can definitely work that out. But if you're interested in Oracle, Arizona workshop, hit me up, baby. All right, let's see. I got to put these headphones. You can barely see them with my hair this long now, which is a good thing. So we're going to go. Oh, I hope this is who I think. And I hope this is who I think it is. But so we have, I know this area code. We've got definitely Key West, Florida. Key West, you're live on the No State Project. What's your name? Where you calling from?
My name is Paul. I'm calling from Marathon, Florida, Keys.
Marathon. So are you near Duval Street at all?
Not right at this moment, no.
Are you familiar with Duval Street?
Of course. I was actually just there this weekend.
Nice. Now, a very close friend of mine is a local celebrity there. When I used to have music on the show, and if any of my videos, if you hear the blues guitar playing, that is Chris. He is a fantastic guitar player, and he's a regular on Duval Street. So definitely look up a guitar player named Chris Case, because he can play blues like no one. I mean, the guy is good. He's good. And also, if you're on Duval Street, if you get an opportunity, not only is Chris great, but his partner in crime, Caffeine Carl. Oh
yeah.
Oh my!
Yeah, I know Caffeine Carl.
You know him, or you just know of him?
Not personally, no. Not personally, no.
So you can
I know of him. Yeah.
You can confirm that Caffeine Carl Wagner is a fantastic guitar player.
Yes, all of the above.
Nice.
Of
Yeah,
course.
They were. See, Chris and Carl 20 years ago were in a band together. They had they were a pretty big act down on Duval Street. And so the band was called Double Bucci. So the actual blues that I'm playing is from, and I need to get that CD up on my channel. Son of a, all the things that I got to make a note of that. Okay. Well,
definitely.
What do you got for us today? Do you have a court case down there?
Yeah, thank God, not since 2 years ago.
Well, did the 2 year ago situation did it end well?
Honestly, it really wrecked my world. It really did.
I don't know if that's what you called about, but something you want to talk about?
Yeah, I do. Actually, Mark, I'm going through a proceeding right now. I've actually been to 7-8 arraignments here in Marathon, and the lawyer keeps basically kicking me out. She says I make too much money. I got a house, blah blah blah. She's not going to give me a lawyer. I'm not going to hire one because they all want money before they even do their job. So my friend / coworker has turned me onto your channel, and I love what you're doing for the American people, man. It's pretty awesome.
I appreciate that. Well, what kind of situation is it where the judge wants you to have a lawyer? I mean, what are you comfortable telling us the nature of the charge?
Absolutely. Recently, I know your stance on DUIs, but it was a messed up charge. I shouldn't have been charged with that, and I ended up having a lawyer, and he's part of the system. On a separate note, what I'm actually calling about is during the time, between it's been almost a year since I had a DUI. I had a hardship license back in October. Back in October, my hardship license was valid, and they pulled me over and basically threatened me. They asked me who I was, and when I asked him the question of why did he pull me over, he just told me, he asked me a question by asking me if my name was Paul, and stupidly I answered.
Well, I think the only thing you should be...
because I was supposedly driving on a suspended license, but I had the hardship license, and he never gave me the chance to tell him that I was looking for work. That was my whole plan for the day.
Yeah, I would just jump in and say that as much as I don't like this, I do think it's sound advice that to identify yourself to the cop, and then keep your mouth shut. Had not identified yourself, he would have arrested you, and then he would have gone through your wallet or your car, and he would have identified you for, by himself on his own. And then he can slap on an extra charge, which could be a lot more serious than what he may have originally wanted to charge you with. And also, whatever we say is going to be used against us anyway. So we can talk our way out of the ticket most of the time.
Might as well just shut the hell up.
You identify yourself, and then you say, on advice of counsel, I am not answering questions, and that's the last. That you don't say another word after that, no matter what why would counsel advise? You just stand mute. I mean, if anything, not that I'm, it's funny when you watch Better Call Saul, the way Mike did it. Mike said one word, lawyer. They would ask a question, lawyer. Yeah, but what about this, Mike? Lawyer. It's funny on the TV show, but I would still say, as great as a scene as that is, on advice of counsel, I am not answering any questions, and that's the last thing you say.
Right. But what this call is really pertaining to is they're trying to charge me for driving on a suspended when I had a hardship license and I was out trying to better my life by getting a second job, because you know how expensive it is down here in the Keys, especially after getting devastated by Hurricane Irma.
I can only go by what friends have told me, and yeah, Key West is pretty damn expensive. So yeah, I'm not able to do a workshop down there and get to jam with Chris and Greg from Miami, who's a fantastic jazz saxophone player who could play blues that make you cry, but because I can't get, it's just too expensive. I can't pay for for in a flight in a room and do all that, even knowing who I know down there in the hospitality business. There's no way I would. I can't fill a room up with enough people to justify it. So because the show is based on the facts. Okay, I'm not going to blow smoke up anybody's. So that's a fact. Right. So, but I get your point. So it seems like that would be a fairly open and shut case that I would do a motion to dismiss, because the facts don't show an actual public violation, because you have the license, the hardship license.
Correct. And the other thing is, every one of these arraignments, all they have told me is that I'm being charged with driving on a suspended. They haven't showed me any of their facts, none of this. So I don't even know, how am I supposed to plead to something that I don't even know about?
Well, they're telling you what it is, but yet I would do the motion to dismiss. But
the thing is, how are these people getting away with, so now we live in a society that we are guilty until proven innocent. How is that fucking legal?
Well,
excuse my language.
Before we delve a little bit more into this there, Paul, what in the hell is going on with the 7 arraignments? I think you've got Balake in Chicago beat, but are you going through the 7 arraignments because you're not working with a lawyer?
Correct.
And each time you have an arraignment reset, you go and they ask you, it just basically goes, because I've heard this before. The judge will say, Paul, do you have counsel? And you'll say, nope, don't want counsel. And they'll just reset it.
Can't afford it. Yep.
And for a minor traffic like this, they're not going to assign an attorney. Okay.
Yep.
You don't have to plea if there's not enough evidence. Plus, I would refrain from pleading anyway, because I'm inclined to file a motion to dismiss first, and then hash out the motion to dismiss. And you could attach, a copy of as evidence, that their facts are completely wrong and couldn't be right, and by attaching a copy of the hardship license.
Right. And that's one of the other things. One of the other reasons why I was calling is because I was trying to get some of your templates and scripts off your website, but it doesn't allow me to choose which ones I want. It just wants me to enter my card. I just wanted to make sure that that was viable, and that's what I was actually dealing with. If it was true and proper.
Well, if you get the motion to dismiss, I'll see that the address you put in will be for Florida, and I have the template that's already crossed over for that.
Okay, so I just need to enter that.
Well, yeah, you'll plug in a shipping address. So even if you didn't want to give the entire address, I don't need it. But if you put in Florida, then I'll know which
right.
I'll know which where it needs to go.
For the motion to dismiss.
Right, for the motion to dismiss. And that comes with the Brady request, the discovery request, the motion in limine, and the proposed plea, and instructions on how to edit and file it appropriately.
Awesome. So I can, because my actual court date is February 11th.
Well, you got time
for the what would be the 8th arraignment?
I would have to, hopefully Blockade can call in today or next on Saturday and let us know, because I think you may have the record there for arraignments.
Okay.
But you have time to prepare for that, to file the documents and prepare, which I like to do role playing, and I can get you into the main chat and maybe into the Discord to help with that, so that when you do go in there, you can stay focused. Like I mentioned before, one of the bigger problems is people allow the spotlight to be taken off of the prosecution's burden of proof. I think to be effective, we cannot take our eyes off of the real issue to be focused on, and that is the prosecution has the burden of proving every element beyond a reasonable doubt, and it's our job to make sure that he has the most difficult time doing that, if not making it impossible to do. Personally, from what I know and in my experience, they can't prove their case beyond a reasonable doubt because they can't prove the foundational claim. Yes, there are disagreements that some people believe that they don't have to prove that they only have a certain line that they need to go to and they don't have to go beyond that. I disagree, and it's very simple. If the prosecution is making the claim against you, Paul, then doesn't due process require that if it's going to be fair, you have a notice and opportunity to defend against those claims?
Absolutely.
Seems right to me.
It should be right, but that sure isn't the game they play.
Well, I tell you, if you flip it on them and you launch a defense based on XYZ, you damn well better believe that they're going to do everything they possibly can to keep you from meeting that burden. And they will never turn around and say, well, you have to prove it, but not beyond this point. You just have to prove this much. I don't think that you could prove anything beyond a reasonable doubt if you're starting with an assumption. If I have to assume X, then Y and Z can't be proven, because you're assuming X. And that's just my background in logic and just, common sense talking.
Common sense.
Well, I don't know if anybody would even dare try to make an argument that you can prove a proposition beyond a reasonable doubt by starting with an assumption. I mean, even if you take it totally in a context of court, how can you possibly do that and not violate a basic principle of law, such as relevance? It doesn't matter what the end result is. Let's say there's 15 steps. We'll just to make an argument, to illustrate this. There's 15 steps to prove to get to 15 and prove 15, you've got 14 steps. what number 14 is that you want to present to prove 15 is completely inadmissible if it's not relevant. So if number 1 is an assumption, how do you get to 2 and all the other steps and still be able to show that it's relevant? I don't.
It's not there.
It's not. That's why also they have to show probable cause. You know, and Paul, I have no problem. I can read, and I'll admit every day and twice on Sunday. Relevance is a very low bar. I get it. The relevance is it has any chance of proving the proposition, any chance. But if you don't have number 1 in that chain, if you haven't laid your foundation correctly, then you haven't shown relevance, and it doesn't matter if 14 is absolutely true and proves 15 is true beyond a reasonable doubt. You haven't shown the relevance. And if you haven't shown it's relevant, you haven't shown that it's admissible. And if it's not admissible, it doesn't matter.
Exactly.
So if someone has a legitimate argument that you can demonstrate through facts and logic that you can start with an assumption and prove your proposition beyond a reasonable doubt, I'd like to hear that. I'm legitimately interested in hearing such an argument.
So what I see you looking at your screen.
Oh, I've got the I'm making sure my recording levels are where they should be.
Yeah.
I've had problems.
I really appreciate what you're doing, man. And I'm definitely going to be calling in again and letting you know what's going on. So I will be getting on your markstevensellers.net and get that motion to dismiss. Hopefully you'll see that, and we'll be in touch.
All right, sounds good. And if you're on Duval Street and Chris Case is playing, definitely go in and show him some love.
Right on. I'll tell him you sent me.
Yeah, he'll know. Well, good luck, and keep me in the loop and let me know if there's anything more we can do.
Awesome, Mark. Thank you. Have a great night.
Yeah, you too. Appreciate the call. Let's see. I was looking at the screen because of that, but I did notice that foreign source. I think he actually made a comment I agree with there. He said Trump was a snake. So I don't know if that was the entire post, but I got to agree with that. But he's saying more. I think he said any published proof that Marc's theory is ever won, or I think it's has ever won. Yeah. There may not be a published case because those are appellate cases, and not all appellate cases are for publication. So there are unpublished cases that you cannot cite as precedent. There's a lot of cases we have that are public, obviously, that have been thrown out. I've posted quite a few. I mean, there's a lot of evidence to show that we have won in court. I'll go back to the old standby because it was such a great success in Wisconsin, where the judge granted the motion to dismiss. Now, yes, people have argued, 2 or 3 lawyers have argued that the judge granting that motion to dismiss is no proof that the motion, the legal arguments in the motion to dismiss had any merit. Well, the evidence is against that argument. You know, we have to look at, as outsiders who don't know what the judge was thinking, all we could do is go based on his order. The judge explicitly granted the motion to dismiss. That's the facts. Okay, that is the. I'm gonna get off the caller line now. Get these stupid headphones off my head over here. What the hell? Those are the facts. They're indisputable. They are not up for dispute. The judge signed an order granting the motion to dismiss. So is it an appellate case that's reported? No, but it's still it is still a public document. It's unredacted. Anybody can go into the Wisconsin court there, whatever. I don't remember exactly which one, and you can verify the judge granted the motion to dismiss. It's no different than someone last year where the judge granted, and I have the documents online on my website, that I shouldn't have done that because I'm not going to be taking any more calls. But you can see that the judge granted the motion in limine. And once that was done, the prosecution, not too long after that, the prosecution filed a motion to dismiss. Because if they can't argue that the laws apply, that's the whole case. If they can't argue the laws apply, they can't make their case, because their case is the laws apply and you violated them. And the judge signed an order granting the motion in limine that they couldn't argue that, because we had established that the prosecution was arguing without proof. So yes, there's plenty of evidence of success that we've had. Do we have appellate cases? I had one in particular, but I wasn't good with this, posting things. And no, I have that one traffic court, probably wasn't a published case because it was the appellate division of the California Superior Court. So still an appellate decision, and but it wasn't in front of like an appellate panel. There was, and when you're at the county level like that, it's just a one judge. So someone, he's saying here, isn't something where the judge agrees with your motion, or that the case was just bad or not worth it. Well, that's not the same thing here in the Wisconsin case. Now, remember, the charge typically is, and I'm not saying that Foreign Source, you're saying this, but other critics have publicly stated that there is no proof that I've had any success at all. It's never been successful. I have never helped anyone be successful. And that's why they have all these conspiracy theories and these theories to try to minimize the, that it is actually proof. So they say, that's what I was saying before, is that the judge, they try to claim that the judge didn't sign the dismissal order and granting the motion to dismiss because it had anything to do with the defense. That had everything to do with the judge being pissed off at the prosecutor. And if I wasn't just some schmuck from Long Island, if I was a lawyer in the real world, I would know and understand that the only reason why the judge did that was to send a message to the prosecutor, even though the prosecutor was ordered to respond and responded. The judge was very explicit in this case, Foreign Source. The judge stated that based on the motion to dismiss, based on my position that they didn't have evidence, the judge wrote explicitly that the prosecution was ordered to respond, but they failed to disclose the evidence or provide the evidence or a legal justification why they were not required to have the evidence. So it wasn't that the judge was just pissed off at the prosecutor. It's because the prosecutor didn't make his case. It's that simple. But if you have one document that where I was successful, it tears down the narrative that I've never had success. So they've always got to spin it. But we have to use logic. We have to use evidence. We have to go based on the record. And there it was explicit. You didn't provide the evidence and you didn't provide a legal justification for why you didn't have to. So they granted the motion, which was exactly what the merits of the motion were. There's no guesswork here. This isn't like a situation where the judge just orders a dismissal or the prosecution withdraws nolo prosequi in the interest of justice, like what happened in New York a few weeks ago. And even if you want to say it's just not worth it, I'll grant you that. But it's not that simple. Why isn't it worth it? If it was so easy to make a case that the code applies and you violated it, what's this whole thing about, oh, it's just not worth it? Where's the trouble? Traffic trials are easy home run. You've got a lot of times you've got complicit judges. They will impeach the witness and still take the testimony. Where is the effort put into a traffic case? There's such little effort that prosecutors will prosecute and have not even seen the file before that day. They're just handed a stack of files and they go in and they prosecute. This isn't a murder trial. This isn't a real crime. This doesn't require forensics. It's not even a DUI where you've got, forensic where you're talking about blood tests and things like this. Or you may have to call an expert. It's a traffic case. So to me, this excuse, well, he just couldn't be bothered. It was too much trouble to make a case that the laws apply to you and you violated them in a traffic court. Come on. Come on, please. So I wanted to just before we go. Yeah, but foreign source, he's saying in the traffic court they can throw it away if it's too much trouble. But I'm saying is why? Is it really true that it's too much trouble? One, I don't think it's possible for them to make their case. And so if they know that you're going to fight tooth and nail, they'll let it go. That's an effective defense. If you can get the prosecution because of your defense to back off, that's a successful defense. So nobody could turn around and say under those circumstances that the way I do things has never been successful before. Or if I can demonstrate to the prosecutor it's too much trouble to prosecute me, I just launched a successful defense. If it was all just nonsensical and actually legalistic gibberish, it wouldn't be too much trouble to defend against because the judge would just deny everything. So it's too much trouble. It's not, it doesn't negate the effectiveness of the defense. It actually proves it. So before I go, Craig had said something about addressing the judge by their first name. Now, this is something that I've mentioned in the Adventures in Legal Land, and I've done it. I have to say it's not something I recommend. SCH is saying, Mark, you rock. Hey, thank you. Thanks for sharing the knowledge. 2 tickets were dismissed for me in New York. Just received your book today. Oh, great. Yeah, I will get that stuff posted, and so hopefully, if we're talking about the one from Long Island, you gotta get back to me so that I can post it with the case number, unredacted, and if I can put your name in there and just redact out your address. So anyway, the by name. So longtime listeners to the show may remember Mike Jones in Phoenix Superior Court. He wasn't going to allow me to do a Rule 9A challenge, and that's so the civil rules in Arizona. It mirrors the federal rule, which is a challenge to an attorney's appearance. They actually have a real client, but okay. It's used a lot in class action lawsuits where lawyers have been disbarred because they really didn't have a client. So the judge, Mike Jones, was not going to allow me to do that. So to throw a monkey wrench in the works and to show just how dishonest this man was and how he was not going to apply the rules. Well, if the rules don't apply, let's see how far we can take it, right? Turnabout. If you can change the context that the prosecutor is being allowed to violate the rule, you do it too and see what happens. So I called up someone to assist me in my oral argument. This did not sit well with Mike. He started freaking out, saying he wasn't qualified. He's not a lawyer. He's not permitted to appear in your behalf. And I said, no, wait just a second. You just said there are no challenges to an appearance in your court. You even said that was the law of the case. So if it's not, if I can't challenge, Bill, you can't challenge, so-and-so. Mike. Well, that didn't sit too well. And I've called other judges by their first name, and I don't advise that people do that. So let's just throw out some solid legal advice here. Don't address the judge by his first name unless you're doing it as an activist and you know that you are putting yourself in jeopardy. There's got to be a reason behind it. It's certainly not going to get the ticket thrown out. It's not going to win you any favor. And if something like that comes out, and you want another judge to rule in your favor, it's probably not going to. It's probably going to bury you in that system. So I really don't advocate using the judge's first name. You're dealing with a child, emotionally a child. And calling them by their first name, you will bring down their wrath. If you were to call Dick Noble in Michigan Dick, you are going to do some significant time in jail. And no, you won't be able to get habeas corpus through for that. So, all right. I appreciate everyone tuning in to the big show today. I will be live on Saturday, but as I'll announce on Saturday, I will not be live next Wednesday and most likely not this next Saturday. So there'll be 2 shows missing, but I will get the success stories up before that. And so we'll have some extra content there. And if you are interested in a workshop here in Arizona, it'll be in Oracle, Arizona, if we do it. Unless so many people contact me and say, dude, we'll just do it somewhere here in Phoenix or we can't go. Then I could do 2. But let me know at markstevens@mail.com or frankrizzo3 on Skype. And if you'd like to help support the big show, and it is very much appreciated, markstevens.net and markstevens.cells.com. So till Saturday when we're live again, that would be Sabato. Yeah. Salud.